It's not running on all cylinders yet, but we're hopeful that some of our members and registrants from agencies that were affected by the shutdown will be trickling in during the day. There were many of them, and we welcome the festive spirit. So, meanwhile, we have a rich and challenging program today, and we're starting off this morning with friend Abbie Hudgens, who I've had the great pleasure to serve for the last 3 years on the state task force on misclassification with, and she's our state's expert on workers' comp environmental labor. And then a long-term friend, John Burton, whom I met when he was at Cornell University, and was were you headed for the Industrial Labor Relations Review? Associate editor. And so I had the temerity to send an article back in the 1980s, and he was generous enough to help us craft it in a shape that it could actually get published. So that was our first encounter, and then I got to know him even better when he was president of the Labor and Employment Relations Association. What year was that, John?
2002.
2002, 11 years ago. And a significant legacy of John's influence on our field was that it was John's initiative to change the name of our parent national association from the Industrial Relations Research Association to the Labor and Employment Relations Association. Although you'll note that TARA has retained we're slowly changing. Has retained its ties to the early name because we still have research in our group. And we thought about changing it, but there was a lot of protest. Not from the academics, interestingly enough, but from others that wanted to retain a tie to that. So this morning's first session then focuses on an issue of great importance for all of us. Workers' compensation, and something that has been a very active area of change in Tennessee, and Abbie's going to share with us some of her understanding and insights regarding those changes. So I'll get out of the way and let John go. We're so grateful to John for coming all the way from New Jersey. And the one thing I want to say, many of you will not know this, but John, he resides and works in New Jersey, has for a decade, I think, been a dues-paying member of TARA, our state association. So he's been loyal and consistent, and it's another reason we're so happy to have him back. Okay, bye-bye.
I think I don't need this mic.
I turned it on.
Okay, so you can hear me? Right.
Oh, yes.
Well, thank you very much. I've known Bill for at least many years. And the article he mentioned is fascinating articles in the study of politics involving labor in the city of New Orleans, which is, as you can imagine, is an absolutely fascinating subject. So we should get him some time to talk about that if he hasn't already given that lecture to this group. It's a great pleasure to be here. I spoke when I was president some 12 years ago, 11 years ago, and they were very fond of this meeting, and so it's nice to be back. I'm going to touch on workers' compensation developments primarily from a national perspective, and I'll say a few things about Tennessee, but Abbie's going to be the one that's going to talk about some of these really significant developments that have taken place in this state, some of which I think are not yet even in effect. Another year or so before some of the provisions start to go into place. And we're going to leave some time at the end for your questions and comments. You'll see this in a presentation I made in St. Louis at the National Organization meeting, and I have to confess, the crowd is about 6 times bigger here today than it was at the national meeting. So hope you'll put mind the recycling. I'm sure there's not very many of you who are seeing this as a recycle event. There's been a few changes since this. Let's see if I get this to go the right direction. All right. This is a definitive introduction of workers' compensation in 900 seconds, which is 15 minutes for those who are somewhat impaired. actually got through this in 15 minutes in St. Louis. I doubt if I'm going to do that today because I do want to add some additional things on Tennessee. So give me 1,000 seconds. A little historical background of workers' compensation, which is actually still relevant today for some of the issues that are emerging in a lot of states, including Tennessee. If you went back to the period before workers' compensation, which nationally was in 1911, that's when the first state laws were passed, if you were injured on the job, the only remedy you as an injured worker had was to bring a tort suit against your employer. And there was dissatisfaction with this tort suit remedy, both from the standpoint of workers and employers. One of the reasons was that there were long delays in getting these cases settled. There was also a situation where workers generally were not successful in these suits because in order to win a tort suit, the worker had to show that the employer was negligent, and very often the injury was not due to negligence, and even when it was very difficult to prove that. And furthermore, employers had a series of common law defenses they could use even if they were negligent. So that, let's say 95% of the cases at least, workers were not successful in these tort suits against their employers, meaning they had no remedy. On the other hand, there were occasional cases, let's say 5 out of 100, where employers were found liable, and of course employers didn't like that because in a tort suit, the recovery can be quite substantial. Full wages, medical care, pain and suffering, and so on. And so it was a situation where both sides felt that something needed to be done to improve the situation. And so we moved in the early part of the 20th century to workers' compensation statutes, beginning in New Jersey and Wisconsin in 1911, and by 1920, most states had passed workers' compensation laws. Some bodies, Mississippi didn't pass it until after World War II, but most states had these laws, and in fact, I don't know exactly when the Tennessee law was passed, but 1918? Okay, so again, Tennessee was one of many that joined the movement towards passing laws. You know, it's interesting history, intertwining of constitutional law in developing workers' compensation. As of 1911, the way the U.S. Supreme Court was interpreting the Constitution, the Commerce Clause specifically, was to preclude a federal workers' compensation statute. So that of necessity, the statutes had to be passed at the individual state level in order, at least for private sector workers. There were some federal statutes dealing strictly with federal employees and railroad employees. Otherwise, the private sector employees had to be covered by state laws. That constitutional limit on federal workers' compensation is no longer valid, I don't think. Who knows what the current Supreme Court would do with a challenge on this issue. But beginning in the 1930s, those of you who are history of the labor will know, the U.S. Supreme Court, in a case involving the National Labor Relations Act, changed its interpretation of the Commerce Clause and allowed states to allow the federal government to regulate matters affecting interstate commerce. And so we had the National Relations Act and, of course, many other regulations, including OSHA, ERISA, you name it, which are federal statutes dealing with the workplace. But for various reasons, once workers' compensation got established at the state level, it has never been dislodged from its role as the primary source of benefits and really the sole source of benefits for the vast majority of workers in this country. I might note that in 1972 there was a national commission appointed by the Nixon administration that recommended federal standards, and it was a unanimous report. Members were nominated by Republicans. I had to be chairman of that national commission. We called for federal standards in workers' compensation, and it encouraged the states to improve the laws for a while, but nothing ever came of that recommendation. So we still have essentially a state-run program. Now, if you look at a workers' compensation statute in every state, there's a basic principle that's involved. Unlike the tort suit remedies that were in place before workers' compensation, where you had to prove that the employer was at fault, the essence of workers' compensation is that the employer is liable even if there's not fault, even if it's an original no-fault system. You have to meet some legal rules, but it is a tremendous benefit to workers that you no longer have to show that the employer did something wrong in order for you to be entitled to workers' compensation benefits. That's essentially what the employees got out of workers' compensation. What employers got was that workers' compensation became the exclusive remedy for a workplace injury. You cannot bring a tort suit, with rare exceptions, in addition to a workers' comp case. So, and the benefits of the workers' compensation statute spelled out in detail in these workers' compensation statutes provide benefits that are much less generous than what you could win in a tort suit. So there's a quid pro quo, to use a Latin phrase, or it's a trade-off. Workers got a no-fault system, employers got limited liability, or sometimes termed the exclusive remedy provision. And that principle has been the central feature of workers' compensation since its inception. Now, there's an interesting development in the last 20 years or so, beginning in Oregon and spreading throughout a lot of states, and finally reaching Tennessee this year, to essentially revise that trade-off that was made back in the 1911 to 20 period. And essentially what the Oregon change, what it said that workers were only entitled to benefits if the injury was the major contributing cause of the workplace injury. Historically, workers' compensation, similar to a tort remedy, would allow recovery so long as the workplace was a contributing cause to the workplace injury. It didn't have to be the major one, as long as it was a non-trivial cause, the employer was responsible for the torts or in workers' compensation. But beginning in Oregon, you had limitations put in to say, not every workplace injury is going to be compensable, it has to be the major contributing cause. In Oregon, this led to a fascinating series of cases which culminated in the Oregon Supreme Court holding that major contributing cause provision was unconstitutional, which essentially meant that those employees who were affected by that provision had the right to bring tort suits. That's not what employers expected they were going to get when they passed that law. We now have at least 15 states that have passed similar legislation, and a lot of these laws have been challenged constitutionally. Some states have upheld the constitutionality, but other states, and currently Florida is a leading example of this. Florida now has a lower court decision holding that the change in the Florida law to make the compensability rules more restrictive is unconstitutional. I think that is what Tennessee was going to have to look forward to, because as of this year, it is now the case that injuries must arise primarily out of and in the course and scope of work in order to be compensable. And so it means in Tennessee, quite a few injuries that used to be compensable before this law was enacted will no longer be qualifying for workers' comp benefits. And then the question is, can those employees bring a lawsuit, a tort suit, which potentially has a much higher payoff for those employees? Now, we'll have to see how that plays out, but that is a risk, if you will, that employers and other reformers, if you will, in Tennessee have taken by adopting this more restrictive languages. sure we have some more questions about that and comments about that. I just wanted to introduce that. All right, now this is just a kind of, from a national perspective, workers' compensation is a very interesting program because it has a mix of private carriers, state funds, and self-insuring employers. And nationally, this is the distribution as of benefits paid in 2010. There is incidentally an updated version of the report this came from the National Carrier of Social Insurance that is included in the flash drive that you received. So you can, for a number of these charts, you can see I haven't quite updated them yet, but the data are there. If you want to look at the material that you can take away from this meeting. And you'll see actually private carriers are the largest source of workers' comp benefits. State funds account for about 17%, and self-insured employers about 23%. Now, Tennessee is a state where there is no state fund. There are about 22 states that either have state funds which are exclusive, there are no private carriers allowed, or there's 4 of those states, and then there's 18 other states, New York, California would be examples, where there are private carriers which are also a state workers' comp fund from which an employer can purchase insurance. And in every state but one, qualifying employers can self-insure. So there's a mix of approaches that are available nationally, which is a fascinating piece of workers' compensation that's been true since its beginning. It's not true of any other social insurance program. This is a figure that shows what has been happening to benefits and costs nationally. And again, this can be updated in this nasty report that's in your packets, in your flash drive. Benefits and costs as a percentage of, or per $100 of covered wages, you'll see that there was a peak in costs in the early 90s, and then a very substantial drop in benefits and in costs until about 2000. And then an increase for a couple of years, and then a decline in most years through 2010. The NACI data actually shows there's a slight increase in costs in 2011. Another data source from BLS, which is some information in your packet, a report that I wrote, shows that nationally costs continue to decline in 2012. But you can see there's quite a movement here, and we are now at a point where in 2010 and 11, the cost and the benefits, costs are lower than they have been at any time since the 1970s. Benefits are essentially where they were at the beginning of this period. And there's various explanations for this. Part of it has to do with improving safety. Part of it also has to do with the fact that a number of states have restricted eligibility for workers' compensation benefits, and there's some research that I've done that's cited in an article by Emily Spieler that's in the packet, shows that in fact in the 1990s the major source of decline in benefits in the 1990s was not improving workplace safety, but is in fact as a result of more restrictive workers' compensation eligibility rules. So it's a mixed picture in the sense of it's nice to have more benefits to the extent it's due to safety. It's not so good if the primary cause is that you're squeezing workers out of the system. That's rhetorical. Now, Tennessee, the NACI data has information on state by state, so you can look at this. Tennessee's benefits in 2011, the year after this, were 76 cents per $100 of payroll. The national average was $1 per $100 of payroll. So Tennessee was about 25% below the national average in terms of benefit payments. In terms of cost, the U.S. average in 2011 was $1.27. Tennessee's costs were $1.09. So, with the NACI data, Tennessee is a relatively low cost state. There are some alternative measures of cost, and again, this is in the material I distributed to you, There's a study done by the Oregon Workers' Comp program that looks at workers' comp premiums. In that measure, Tennessee is slightly above the national average in terms of workers' compensation premiums. But as a simple point that I suspect we can get back to this in the questions, Tennessee is essentially in the middle of the country in terms of cost and benefits. Not particularly high costs, slightly below the national average in terms of benefits. This is a figure that, again, is a national figure, and it has to do with the share of overall benefits accounted for by cash benefits as opposed to medical benefits. And you'll see that there's been a substantial change since the 80s. It used to be that medical benefits accounted for about 35%, 33% of all benefit payments, and cash benefits accounted for the other 2/3. Over time, that has changed so that now it's essentially there's no difference, and there's other measures of this that actually show that medical benefits are greater than cash benefits. But in terms of paid benefits, the NACI data show that the two components of benefits are basically the same. I might note workers' compensation medical benefits are unusual compared to other types of medical benefits. There are no deductibles. Well, that the employer is responsible for the first dollar. There's no co-insurance. There are rare exceptions to that. Employers pay 100%. And the premium is paid by the employer. With again some very rare exceptions, employees do not pay any portion of the premium. So it's a very attractive healthcare system, and that has been a source of tension because if you're working for an employer that doesn't have healthcare, and you have a marginal condition that's a back injury, you have a lot of pressure on you to try to get that injury classified as work-related so that you can get into the healthcare system provided by workers' comp. Otherwise, you might be liable for the whole thing yourself. Now, this is going to be fascinating to see what happens under Obamacare as to where these incentives are to shift in or out of workers' comp as compared to healthcare that an employee may buy through a private exchange. And this is an interesting history of what's been happening to workers' compensation in terms of statutory enactments. This is a national analysis prepared by the National Council on Compensation Insurance. It's the actuarial organization that does work for the private insurance industry. And you'll see that these are 5-year cumulative totals of changes in workers' compensation benefits due to enactments of more favorable laws or changes in medical fee schedules. And you'll see that even in, this goes back to 1959, that during the 60s, essentially, there was substantial improvements in benefits. The 70s, partially in response to the recommendation of the National Commission, you had benefits going up over 50% in that decade. The 80s, essentially, still some improvement. And then, beginning in the early 1990s, for the first time in the history of this length of time, I would guess probably going back to the 1930s, for the first time we began to see benefit cuts that were greater than the benefit increases. And that pattern has persisted essentially since the early 1990s. We're in an era where states are scaling back on the required protection provided to workers nationally, and that is certainly true, obviously, in many, but not all states. All right, and then finally, if you want the data, this says this is the website that I operate. You can contact that. Or, again, I mentioned the fact that in your packet, on the flash drive, if it's a packet, that's so old-fashioned I have, this would actually have pieces of paper you might take away from a meeting, but you're going to take away this little, where's the flash drive here? On this flash drive, each of you will receive when you register, you'll find a copy of the PowerPoint you'll find a copy of the NASA report, you'll find the article by Emily Spieler and me, you'll find an article that I've written on workers' compensation costs that has some more detailed analysis of how you measure cost differences among states. Well, I hope this gets us started. I think a little more than my 1,000 seconds, I think, but I'm looking for comments, and we're interested in the suggestions that you have for changing the world and whatever questions you might have in a few minutes. Thank you.
Appreciate you all letting me come today. I'm Abbie Hudgens. I'm the administrator of the Workers' Comp Division for the state of Tennessee. It's an interesting topic. I suspect there may be some questions. I'm just going to go over, trying to be mindful of the time we have this morning to go over a few points. Perhaps give you a little bit different perspective of what the state agency in Tennessee has done, and then invite questions if you might have it. One thing that I think is helpful to know what's going on in Tennessee is to kind of understand what we're trying to accomplish with the major changes that were made this past year. And just to put everything in context, these changes went into law in April, but they are only effective for injuries that occur on or after July 1, 2014. Let me tell you something about the context in which these reforms were made. If you're in government, there is always the challenge to keep the balance, to keep the pendulum in the right place. You also know sometimes in government we tend to swing a little bit too far one way, and then we readjust and sometimes go too far the other way. There was really a groundswell from those people who provide these jobs to do something about what they felt like was a pendulum going too far one way. Now I know if you look at the NESI data, it says one story. If you look at the Oregon study, it says another story about the cost of workers' comp in Tennessee. But if you look at keeping employers in Tennessee and you look at their cost compared to the states around us, every state that touches us, they are our primary competitors for jobs. Every state around us has significantly lower costs. That's just sort of the pragmatic side of the pressures that are on government. There's an additional pressure that probably might not have come up in general conversation, and that is a trend that we are seeing when I talk to fellow regulators across the state, across the country. This would include the Southeast International. I'm on the Executive Committee for the IABC, which is the International Association of Industrial Accidents Commissions and Boards and Commissions. And that trend is that employers are seeing less and less value from the Great Compromise. As you mentioned, the Great Compromise was the employer gave up the right to say, I don't pay it unless I'm at fault. And the employee gained the right to say, if it happened because of my job, I get a benefit whether I was at fault or whether my employer was at fault. What has happened over the years, and you did mention that we are having lower numbers of severe injuries because of technology and the changing face of what people do. People are noticing that, and they're saying, employers are saying, I would rather take my chances in court. I think I will come out better in court. That's why you see such interest in Texas, where you do not have to have workers' comp at all. It is purely discretionary on the part of the employer, except for those jobs that tend to have more serious injuries, such as construction industry or oil drilling industries. This past year, reform was passed in Oklahoma that gave those employers the right to pull out. That's a real trend, and those of us that are interested in a fair and balanced benefit program for injured workers would ignore to the detriment of the people we're trying to serve. So that was part of the background of the reform in Tennessee. Another background piece for the reform in Tennessee was the desire to make the system work better for employees and employers. It's easy just to look at the dollar amount of benefits, but what has been lost in the conversation is what happens to employees in this process. We have a system that has been in the courts in Tennessee. It may take people years and years and years. In fact, we had 2 Supreme Court cases year before last where it had been in the court system for 12 years. Think for a minute what happens to an employee who's injured and it takes them 12 years to ultimately get a benefit. You know, we hear a lot that people have to be able to pay for their house mortgage to put food on the table. But what's happened in these years where they don't have a job and they have no benefit? That is a real concern, and we felt like it was a weakness in Tennessee's system. What about the employee who is the bass fisherman over the weekend? He's a professional fisherman. He spends his entire life using his right hand to cast, and he comes in and he has minimal amount of keyboard responsibilities in his job and files a carpal tunnel injury. In the state of Tennessee, that would be, in the past, would be found compensable. So while we certainly need to, it's an area again where we need to find a balance. Dr. Jim Talmadge, who is a specialist in occupational medicine, said that we in the country have lost sight of the fact that workers' comp has to do with why the injury occurred, not where it occurred. So if the why was because I spend all my off-time duties casting and I'm able somehow to give a win, that's not really what workers' comp was meant to do. So that was one of the reasons, background for our reform. So with that sort of notion of trying to maintain the balance, trying to keep the system that met the needs for both employees and employers, because after all, that's what the original compromise was all about, was to provide an agreement so that we could take care of workers, but in such a way that we could keep the employers on board. We had reform this year, and it had, I'll just tell you briefly about some of the components of the reform. The one people look at, probably that stands out the most, is we moved the system from Chancery Court and Circuit Court to a new court that was established by the legislature, which is the Division of Workers' Comp. This new court, that's all they'll do. It's sort of like the old-fashioned Gerber baby food commercial, where babies are our business, our only business. These workers' comp judge, their only business will be workers' comp. The hope is that they will be able to hear these cases more expeditiously and bring really sound knowledge of the workers' comp law to all their findings. So that was a big piece of the legislation. Another piece was that causation, standard of causation was changed. Rather than could be, it was, if you looked at what happened, it was possible, not necessarily probable, but it was possible that the work could have somehow been involved. It was considered compensable. Under the new law, it has to be primarily because of the work. This is different than some states. We are, again, as you mentioned, sort of in the middle, because some states will have it must be substantially responsive. The work must be substantially the cause. We did not go that route. We just went primarily, and primarily is defined as more than 50%. So it could be 50.00001. But it has to show that basically the job was responsible for the injury for which benefits were being claimed. Another change is in the basic construction of the law, and where that was liberally construed in favor of the employee. Under the new law, it is an equitable construction that favors neither one nor the other. Again, that goes back to the premise of the original compromise, which was something to take care of employees. We always have to remember this is a no-fault system, so there has to be that movement of the pendulum back to the center. There were also some changes that were made to help the employee. One of those is the implementation of a new ombudsman program. We're in the process right now of developing the job plan and the knowledge, skills, and abilities that were necessary for that program. This will be available to people at no cost if they have no representation, that will walk them through what's involved in a workers' comp claim, that will take the mystery out of it, and it will make it easier for them to understand what they must do, how the system works according to the law. That will be in place before the law actually goes into effect. Another thing that people may have overlooked when they look at the law is that the law has, as far as permanent benefits, has been made much more automatic. Instead of having to wait for years and years and years, when an employee reaches maximum medical improvement, they are entitled to an initial benefit immediately. That is an incredible change, and that does what we're trying to do, which is to take care of one of the two principal members of the situation. So often when we talk about workers' comp, we talk about insurance companies, we talk about attorneys that represent each side, we talk about adjusters, we talk about doctors. We must remember that the two parties really involved in workers' comp are the employee and the employer. Those are the parties that we try to keep in mind. And that's one reason why we feel like the delivery of the initial permanent partial disability benefit immediately upon reaching maximum medical improvement is very important. There were some changes in the permanent partial disability formula. The maximum amount under the new law is less than the maximum amount under the previous law. We feel like that is balanced by the fact that it is more immediately delivered. Employees do not have to wait for this amount. And we still have what we call an escape clause, which is in section 242 of our law. It takes care of really unusual circumstances where the basic benefit in the law does not meet the particular situation, which we think will address those needs that you can't reduce to a simple formula. Another part of the law that's kind of interesting is that it requires us to have statistics and metrics to show the effect of the law. We will have to start reporting to the legislature beginning in 2015. And by 2018, there's a sunset. So this program, if it does not show that it's making a difference for the people of Tennessee, will face a sunset. I think those are the big issues. I could talk some more, but I would like to just touch on one thing. It's just an anecdotal comment. We've looked quite a bit at what we think the effects of the Affordable Health Care Act will be. And as I talk to my colleagues around the country, you can get a continuum of responses. Everybody seems to think that it's all over the board, but we're beginning to think that it probably will increase somewhat the number of claims because there is an increasing sense that many employers, especially smaller employers, are going to opt to pay the penalty rather than provide health coverage. And that some employees, especially those who are having a hard time financially, may opt, surprisingly, to pay the penalty rather than to have health coverage. And as you mentioned, if there's nothing else to pay for it, it becomes there's a moral hazard there to try to make your health care costs be covered by workers' compensation. The other thing that I wanted to just mention is this goes to the constitutional challenge. We did look at that particular section. We think we're in pretty good shape in Tennessee based on prior opinions that have come out from the Supreme Court about the 2004 legislation. We certainly did look at that. You're right that those challenges could come forward, but the right does reside with the legislature to define the outlines of the workers' comp program. But it's sort of one of those things we're going to wait and see. Now, I typically, when I talk about the reform in Tennessee, I take 3 hours. So I've really truncated that, but I would like to give everyone a chance to ask questions if you would like to, because we do have kind of an unusual situation because of the amount of changes we're making all at one time. That's fairly unusual for states. So thank you so much for listening.
We're going to have to take questions here. I'm going to use this mic.
There are 2 switches, John. One up near the top.
Okay. Oh, what about? Oh. Okay. Questions for Abbie or John? Comments? Yes, go ahead.
Yes, I have. Listening about the tort suits, how the workman's comp actually makes it more difficult to file for a tort suit. With the changes in the workman's compensation laws in Tennessee, how will that affect the probability of additional tort suits being filed with this new law?
Well, the section of the law that says that workers' comp is exclusive remedy was not changed, so it remains the exclusive remedy. That's an area of the law that the Supreme Court has held very firmly to. I read some opinions that I thought, if I were a judge, I might find a different way, but they have historically always stood behind that. The only thing that would change that is if, for some chance, there were some finding that some part of the new law was considered unconstitutional, that would raise that issue. In the state of Texas, their experience, of course, they have no exclusive remedy. And that's one reason that we find this push to maybe get away from the grand compromise, because they've really not seen a very big uptick in their litigation. I know that just a personal experience, I was the risk manager for City of Nashville and Davidson County for about 4.5 years, and they're not under workers' comp. In the state of Tennessee, government entities don't have to be under workers' comp. So I was able to see how that works, because in that there, you may actually file an injured on duty claim and file a tort suit at the same time. In 4.5 years, there was 1 suit. So I think when we look at the grand compromise, we don't appreciate that the threat of tort claims has reduced, because, of course, the employer has to be found negligent. And a great many workers' comp claims, the employer is not negligent.
Well, I might note that in Oregon, they didn't change the statute either. They retained the notion of workers' compensation was exclusive remedy, but the Supreme Court ultimately said, well, that's not constitutional. So I don't know what's going to happen here. You're probably right. Tennessee is not Oregon, but it is a risk. We just have one comment on this notion of rebalancing, historical balance and so on. If you went back to 1990, the legal doctrine in, as far as I know, every state, what can be summed up by what used to be put the following way. The employer takes the employee as he finds him. Now, that's obviously has a sexist overtone, but what it meant was that if you, for example, were an employer and you hired someone who had a previous back problem, and there was an incident at the workplace that triggered a substantial disability, even though the injury at the workplace was rather minor, the employer was liable for the entire consequences of that incident. So that when we talk about rebalancing, we're talking about not rebalancing to what the workers' compensation law was in 1911, but what it was for a little more than half a century has now been thrown out in most states. So I don't call that rebalancing, I call that changing the marker between what's compensable and non-compensable in a way that is historically much less beneficial to workers.
Trust I have a chance to comment on that.
Sure, absolutely.
I would take a little issue with what you have to say and add a few comments, because your comments are based on the notion that that idea of taking the employee as you find it has been thrown out. And it has not, as yet. We'll have to wait and see what the courts say, but that principle still is in place. What the difference is the precipitating event. If you have an employee that has an injury that really is not because of the workplace, they will not have a compensable injury. It does not, so it's a fine distinction. We'll have to see what the courts say. But the issue of you take them as you find them is certainly still, as far as I know, going to be in place in Tennessee.
I don't see how you could read your statute that way, but obviously you're the expert. It seems to me if it's got to be the principal cause, the primary cause, then the triggering event presumably has to be the primary source of disability. At least that's the way it's been interpreted in most states. All right, let's get other people a chance here to get involved. Because somebody else had a hand up back here, I think. Yes?
What standards is the legislature going to, how are they going to judge the effectiveness of the law?
Yeah,
If
that's
it sunsets, what happens?
That's a wonderful question. That was not our change to the law. We did not put it in there. We'll be hopefully finding more information as we go along. They sort of put the burden on us to demonstrate. Now, the things we are looking at are really the length of time between maximum medical improvement and conclusion of their claim. We will be doing some satisfaction surveys. We are right now looking at measures that we think might be effective to tell the story of the difference between workers' comp 4 years from now and workers' comp in the previous session. But they were not explicit at all as far as what they would examine. They just wanted the right to take a look at the system in toto to vote on whether or not to sunset it or not.
So they asked for metrics, but they didn't tell you what metrics those were going to be.
You have it, exactly. Now, the nice thing is it really gives me a wonderful opportunity to talk with people in California, Oregon, Texas, who are noted for having a lot of metrics, and we've talked to them a lot. If you look across the states in the United States, there is not a consistent set of metrics that anyone uses. So we're having to chart sort of new territory, but we are talking to other states. It'd be nice, I certainly mentioned that, and that's why I'm volunteering to be on the research committee for the IIPC. It would be nice if there were some limit on what would be good metrics for a workers' comp system.
Incidentally, so that I don't come across as being totally unsympathetic to changes and changes in Tennessee, if you went back 2 or 3 years, there were only 3 states in the country that had systems that substantially involved the courts in the determination of workers' compensation cases. And Tennessee and Oklahoma were 2 of those states. Both of those states just last year have passed laws that have changed the administrative structure in a way that I think is in the long run, much preferable. And that is the state agency now is in control of the case through a couple of levels of decision-making, and there's no separation between permanent disability cases which go into the regular courts and so on. So I certainly think that some of the changes in Tennessee have been highly beneficial, or will be beneficial. It's going to take a while to get those implemented, but I applaud you for those decisions.
Even in Oklahoma, while they had a court system, there were courts just for workers' comp, so it was sort of quasi between the two. Only Alabama and Tennessee actually had just gave it to the civil courts to deal with. And I don't think there's any prospect of change in Alabama, but there certainly was a desire for it in Tennessee.
Well, I'm going to go back to my to comment on this cost comparison among other jurisdictions. The Honorable Gilbert P. Smith has pointed out to me that Tennessee is one of only 2 states that has 6 contiguous states, the other being Missouri. And I think there's a problem for workers' compensation because the more states you have that you're in contact with, the better the chances are you can find a couple of them, or maybe a bunch of them, that have a cost or a lawyer than yours. I don't remember the 6 states that... 8. Oh my gosh. Well, there's one other expert witness here, 8 states. I did look in the next report. There were only 2 states I was sure of that you were contiguous of were Kentucky and Tennessee, or Kentucky and Georgia. And both of them have higher costs, according to NAFSI, higher costs than Tennessee. So it depends on which data you look at, which makes it more complicated. And here's my solution to this contiguous problem. Because I think if you have this rule that we're always going to be looking at neighboring states, essentially you're going to race to the bottom. You know, it's a way to turn workers' compensation in this country into Bangladesh. How low can you go in order to have costs that are more than most of your neighbors? Well, mathematically, it's impossible to do that without having a runaway cycle. So here's my rule. We're going to pass a federal standard that says no state can have more than 4 contiguous states. And then I think we'll make a major contribution.
Not going to work.
Yes.
I really appreciated that you shared with us that you had been part of that commission during the Nixon years, I believe.
Yes.
And that while we have, as we have in so many other things, America operates as 50 semi-autonomous republics who communicate with each other, but on many issues are quite variable and independent. Given your experience and almost unique perspective, having been a part of that initiative at that time, could you share with us some of your understanding of why we have not seen more mobilization to have federal legislation and oversight, a federal program that would harmonize among the states and really address this issue of the states competing with each other, as we've suggested Tennessee does? Because it seems to me that there would be interested parties, such as labor unions who are in this room, who would have a strong incentive to have many years ago, when this was happening, mobilized. So why do you think there hasn't been more?
Well, that's a good question. I think there's a variety of reasons. One is the National Commission I chaired was created by the Occupational Safety and Health Act, and you recall that OSHA law essentially displaced one of the historical areas where states have always been in control. Safety and health have always been a state domain, and OSHA wiped them out. Now, obviously, you can get approval and take a state plan back, but basically it's just not a federal program. That really traumatized a lot of states. Politically, OSHA was never a big factor at the state level, whereas workers' compensation has been. And I think that's part of what our problem here is that there's a lot of interest groups, attorneys, both sides of the face, and frankly unions, who would prefer to keep it at the state level because A, there are a lot of jobs involved. I might know workers' compensation in most states. I have no idea about Tennessee. In most states, workers' compensation administrative appointments are political clubs. You know, it's a place that patronage is the dominant factor in who gets the jobs in the workers' comp system. When I was in New York, in order to be a clerk in a district office, you had to have a letter from the county chairman of the Republican Party. So, you know, we're talking about, and states, therefore, do not want to give up for a variety of reasons. Even unions, historically, unions have some strength at the state level. factor that becomes involved here. When unions were important at the state level, lobbying on workers' compensation was a major function that they played. And that meant that even the union movement was divided. The national union was in favor of federalization of federal standards, but a lot of state feds were not. So that's kind of the explanation. And then another factor, I would say, what do you do? Well, the National Commission, if you're concerned about, as we were, downward pressure on states because of this issue that people was talking about. You know, contiguous states have lower costs, puts a tremendous downward pressure on the system. What do you do about it? Well, the thing that we recommended against was federal workers' compensation program. Because in our view, and I think most people's view, still, the federal workers' compensation programs are not models that you want to emulate. They have a bad reputation, and the reputation is deserved. And so the alternative was federal standards, but it's tricky to get federal standards in workers' comp. The program is so complex to try to read 19 we recommended, and by the time I got to Congress, they threw in a bunch of other things that just didn't make sense. So it's not easy to formulate some meaningful standards for workers' compensation. So I don't think we're going to see federal standards. In fact, I don't know. I'm sure we won't see a federal program either. I'm not sure where we're going on this, other than the last 20 years, we've resumed the race to the bottom.
Just 2 points. One, to speak to the political nature. Since I'm the administrator, I guess I need to clarify that a little bit. In the state of Tennessee, part of the Reform Act was because of this. And it was to make the Division of Workers' Comp an autonomous unit of the Department of Labor, independent and part of the Department of Labor only for administrative purposes, budgeting, HR, that type of thing. And the reason was for that was because there was some history where as new Department of Labor commissioners came in, appointments, there was the concern that their appointments would be made for political reasons. So in the legislation, there actually was a real effort to avoid that. Many people have brought up the issue of the appointment of judges. The judges will be appointed by the administrator, and that's myself. But we have established a program that's modeled on the selection of judges in the state of Tennessee. It's now defunct, nominated commission, but we are modeling that on that process to be so transparent and so obviously based on merit that there will be some array of concerns of political appointments.
Well, that's a wonderful development. Let me just give you another example of what's a distressing development this year. North Carolina, which historically has had a very good workers' compensation program, and the judges were appointed for fixed terms. The legislature has now passed the law abolishing all the fixed terms and making the administrative law judges or their equivalents appointees of the governor serving at his will. So, you know, talking about politicized to the nth degree, Tennessee's going the right direction. North Carolina has it.
We do have terms. The judges will, and that's part of the desire to make sure they'll have terms of 6 years, and the first level of judges will be maxed out after 3 terms. There's an appellate level, which is appointed by the governor. There are 3 of those, and they'll be maxed out after 2 years. So it's hard in a political environment to have a perfect system, but they did certainly try to structure it in a way that increased the odds of it going on.
Well, this aspect of Tennessee, I certainly think we're going the right direction. We applaud that as another feature of the law that sounds very good. So,
Well, there's just one other point about the nationalization.
yes.
An interesting aspect there are, because of the concern about how the federal workers' comp programs have gone, and because of the increased concern and almost panic over the percentage of employees in Tennessee who are now in the country, who are now on disability, there actually was a white paper being floated around suggesting that they turn the disability programs over to the states. I'm glad to report that cooler heads have prevailed and that's disappeared. But I think people are concerned about that issue, that somehow we focused on benefits for disability and we've encouraged people to go there as a career choice, and we need to be focused on a way to return people to a happier and a more successful life. It's the greatest challenge that we face, I believe, not just in workers' comp, but as the country as a whole.
Thank you all.
Any other questions? Yes.
Abbie has raised, I think, a troubling argument, and no doubt truthful, that the argument is that on the employer side is let's do the workers' comp for fear of tort litigation. And apparently that trepidation of tort litigation is the argument that it really isn't there. It really isn't a problem with workers' comp tort claims for their injuries. I'd be interested in hearing the experts' thoughts about why that's happened. Why aren't workers in, for instance, Texas who are injured bringing tort suits?
Well, I don't know the answer to that entirely. I think a lot of employers in Texas, I think in Marriott, which I know something about, have set up pretty good private disability plans outside of workers' compensation, and that they've taken good care of their workers. Now, I can't say I'm sure that's not true of every worker in Texas. I'm not sure whether or not more tort suits. It's a good question.
Well, one of the answers has to do with the change in the workplace since the early 1900s. We don't, because of the nature of the work, increased more things are automated, partially because of OSHA. The number of catastrophic injuries has gone down. We have a large increase in the amount of employment that's with the service industry. With the service industry, there are less obvious hazards. And I think those people in Texas, you will find that people who would like to opt out or not opt in tend to be in that type, we call them a big box employee. And often those types of people, if their workers' comp injuries are not those you would necessarily say it's because of their job or it's because of their work environment. So I think that contributes. What you don't see in Texas are employers who are involved in oil drilling, offshore drilling, or construction. You don't tend to see those interested in this. But the service industry is a very large component of our total workforce, and those employers are really funded. A lot of injuries are today. Employers are finding that a lot of the injuries are because of motor vehicle accidents. And motor vehicle accidents involve the employee themselves. Unless you can show that the employer had substandard maintenance of the equipment, it would be difficult to show that the employer was responsible for that accident. The employee runs a stop sign and has an accident, they're not going to have a recourse in tort. So all that, they look at their claims and they go, well, in a tort case, we wouldn't be responsible. I think that's part of the answer. But I think the biggest answer may have to do with just the changing nature of the work employees in America are doing.
Well, I think another factor, the construction is very dangerous in Texas. It's notorious for having some of the worst records of deaths. And a lot of the workers that are killed are illegal immigrants and probably are not very likely to bring tort suits. They're intimidated against doing that. So I think it's a little hard to know exactly, I don't pretend an expert on Texas, but it's a very complicated situation as why that tort system isn't more effective. I see we have a wonderful leader here, the president of the organization is standing up saying, your time is up. He doesn't quite that
Well, we're very flexible on time, as people discovered yesterday. But I don't think we could have had two better people to give us insight and more understanding about the current state of workers' compensation, both nationally and certainly here in Tennessee. And thank you both so much for a short break now. We'll We'll reconvene in 23 minutes at 10 o'clock. We paired the sessions this morning. You'll see that we have Heather Rose here from Massachusetts, and someone who was just asking a question, Matthew Peace, is here from the Nutmeg State, from Connecticut, to talk about initiatives on workers' regulation of workplaces, and particularly with regard to misclassification and unreported work. Tennessee has been really very active in this area as well with change, and we're just finishing up a 3-year task force looking into misclassification and unreported work in the construction industry. And July 1st, Governor Haslett signed a new law into place, and we'll probably talk about that a little bit later, but I'm hopeful. I don't know if you can stay, Abbie, for this next session. Because you were on the task force with me, it'd be great if you could.
I can't, as you can imagine, July 1st is rapidly coming.
We are.
I would just throw in, and as a sort of a teaser for what Matt will say, perhaps one reason that people might not be afraid of tort, if you don't actually cover your employees under workers' comp, you don't have to worry about a tort suit. You can just say they were an independent contractor.
Yeah, independent contractors, not covered. Okay, well, thank you again, and thank you for coming today.
It was nice.
Okay, so we'll start at 10 o'clock for our next